Good morning, Chairperson and members, and good morning to the members of the public. Thank you.
Thank you, Madam Maseti. I also have Madam Zandi Limpungo, who's a part-time regulator member and PPS member, who also chairs the Human Resources and Remuneration Committee. Let me skip that and proceed. I hope when she joins, she will then announce his arrival. Also have Mr. Fungais Banda, who's a part-time regulator member, as well as a PPS member, who chairs our Information Technology Governance Committee, the ITGC. Mr. Banda.
Morning, Chair, NERSA colleagues and members of the public. Thank you.
Thank you very much. Members, at this stage, I would like us to then move to the adoption of the agenda. There are two substantive items that we are going to be dealing with today. Any changes suggested by show of hands? Seeing that there are no hands, members, may you please raise your hands in support of the adoption of the agenda as presented. Thank you, Madam Maseti. Thank you, Mr. Banda. Thank you, Advocate Stole. I also support the adoption of the agenda.
Chair, maybe it's I can't hear you. Chairperson? You're on mute, Chairperson.
Oh, thank you. Thank you. Sorry there, I was muted. I would like just to then proceed, members, to the declaration of interest under item 4. And I implore all of you members as well as management to ensure that you fill the declaration of interest forms and submit them to the Secretariat, Madam Patience Maswanganye. Any interest members to declare verbally in this meeting? By a show of hands? I don't see any hands, so we'll proceed on that basis. Without much ado, then, I would like us to go to item 5, which is a submission for recommendation to the energy regulator for approval, which is updated frequently asked questions on the tariff methodology for the setting of tariffs for the petroleum pipelines facilities, version 8. Over to Madam Tua, the executive manager, and your team.
Thank you, Chairperson, and good morning to the members and the colleagues and the members of the public. As we might remember that our tariff methodology for setting of the petroleum pipeline facility, the tariff thereof, has been recently reviewed and updated. We therefore find the need to also update the frequently asked questions which relates to this tariff methodology. Ms. Yogana will then talk to us in terms of the silent features of this frequently asked question. Thank you. Over to you, Ms. Yogana.
Thanks, ma'am. Morning, Chair, members and colleagues. The purpose of the submission is to request that the PPS considers and recommends to the energy regulator the approval of the updated frequently asked questions on the tariff methodology for the setting of tariffs for petroleum pipelines facilities, version 8, attached here to its Annexure A, as well as to consider and note the summary of the FAQs for the methodologies for the setting of tariffs, as well as for the approval of tariffs for both the petroleum pipelines and storage and loading facilities. And this is intended for internal use by the NERSA's communications teams at the reception and call center areas. It is attached here to as Annexure B. We'd like to highlight that the Annexure A comprises of Annexures A1 and A2, where Annexure A1 contains the updated FAQs with the tracked changes, and Annexure A2 is the clean version of the updated FAQs. Also in Annexure A1, the strike through on the red text represents the deletion, and the red text represents the new additions to the FAQs. And as a bit of a background, in the 2019-2020 financial year, NERSA embarked on a process of reviewing the tariff methodologies, which was necessitated by the need to optimally advance the objects of the Act, while also addressing the challenges that were encountered with the previous versions. So the revision of the tariff methodology for petroleum pipelines was completed in 2023 with an ER approval on the 30th of March 2023. And as part of the continuation of the revision process of the tariff methodologies, the changes that were made during the review process were incorporated into the FAQs. And so the FAQs for petroleum pipelines have been updated according to the revised and the new components of the version 8 of the tariff methodology for the setting of tariffs as contained in the submission. Furthermore, while considering the updated FAQs for the tariff methodology for storage and loading facilities, the PPS of 4 October 2024 recommended the development of the summary of FAQs, which would cover both the tariff methodologies for internal use by the communication staff when dealing with the calls from stakeholders inquiring about the tariff methodologies. Hence, the submission includes the summary of FAQs that is attached here to its Annexure B. It is therefore recommended that the PPS considers and recommends to the energy regulator the approval of the updated frequently asked questions on the tariff methodology for the setting of tariffs for petroleum pipelines facilities attached here to its Annexure A, and considers and notes the summary of FAQs for the tariff methodologies, which is intended for internal use by NERSA's communication teams, attached here to its Annexure B. Thank you, Chair.
Thank you very much, Madam Yokwane. Members, any questions, comments, or guidance to the team by show of hands, please? I don't see any hands. Oh, Madam Aseti, over to you, ma'am, then followed by Mr. Sbanda. In that order, please.
Thank you, Chairperson, and thank you to the team for the frequently asked questions. Chairperson, my question or the issues that I'm raising are meant really to improve in the way that we framed the questions, so that stakeholders don't get to see something that is not necessarily answering the question. I would like to start off with, for instance, the question that says, how does NERSA determine the tariffs? We are not answering how does NERSA determines the tariffs. So I think maybe we needed to ask a different question there. I'm saying this because I'm looking at the answer that is provided. The answer that is provided is not talking to the specific question that is asked. So we may need to just change then the question itself. So because all we do there is to mention that NERSA, for instance, approval or setting of tasks, we don't like answer straight to the point. Because if we want to talk about the mandate of NERSA insofar as storage and loading facilities, you want to differentiate to say that we've got a different mandate when it comes to storage and loading facilities. So let us do that so that stakeholders understand that our mandate is just to approve when it comes to those two. And when we approve, we would not set, even if there is a difference in the calculations, and therefore to the extent that the difference is significant or substantial, then NERSA would reject that application and ask the licensee to address certain things. So that's how, maybe that is how we're supposed to frame this, if we want to address that aspect for the approval part. And so that licensee understand our processes, understand that should they not do things right in accordance to the methodology, this is what is going to happen. And then if we want to then talk about the setting, we can then say that we also do have a mandate to set, and that mandate to set relates to the petroleum pipelines only, and then we deal with the methodology that we make use of to say that the methodology seeks to do X, Y, and Z, and this is how we will do it. So we don't have the how we will do it in the response that we have provided. I just made those examples, Chairperson, just so that the team can appreciate how we should convey and communicate to stakeholders in a simple way. There is a number of these questions that are not answered in the way that they should, Chairperson. I mean, there are some here that are talking how, okay, at the how long as well, we need to also just be a bit careful there in terms of our own service standards, considering the fact that if we say how long does it take NERSA to take a decision on it, on the tariff, we may need to differentiate between the mandate to set and the mandate to approve. So I don't know whether we take 6 months for both. And even so, even if we have done so, but we should also factor in some improved service standards, because I don't think that we can always take 6 months for these things. We probably do want to indicate that we may take less than that, even 4 months, if because it is doable if we are considering the the approval part. For instance, if I were to use gas, for example, we talk about 120 days after the PGS has sort of approved the discussion document. So if it's 120 days, it is definitely not 6 months. It is less than that, and that has to do with the approval part, and also even the tariffs as well as the prices. So if we can also just consider issues of improved service standards and efficiencies in taking the decisions. So I wanted to also mention that part, Chairperson, to the extent that when we do these things, we may also want to factor in some efficiencies, and also just indicate that maybe at the maximum it may be 6 months. However, it can be concluded, or the decision may be taken less than that, but also we need to sort of improve on that. Those are my points, Chairperson, but there are other areas where we really need to look at how we framed the questions and how we framed the responses, so that we can make it easy for people to understand our processes, which is the purpose of this question and answer document. Thank you, Chairperson.
Thank you very much, Madam Maseti. Mrs. Banda, may proceed, sir.
Thank you, Chair. Chair, my comment is probably along this same lines or similar lines as Ms. Masset. I think we need to strike the right balance between industry and the general public. I know that this document probably is intended for licensees. But it's not only licensees that probably go onto our website. So we need to make sure that our documents are accessible to the general public. So the question that I had in mind for me was, in doing all of this, what's in it for me as a member of the public, or what's in it for the consumer? We delve straight into questions without providing a sort of a background or a context of what we are doing, why we do what we are doing, and generally what's the benefit to the general public or to the consumer. So I found I couldn't find the consumer voice in all of this, but like I said, I know that that's not the intended audience. But I think we need to strike the right balance. So we don't always have to be technical in terms of explaining ourselves. And so probably there's a way of simplifying this, or providing, maybe let me put it this way. We probably need to have a context section before we get into the questions, so that whoever reads, whether it's a licensee or anybody else out there, you've got the context, you are able to relate, and you know why NERSA is doing what they are doing in setting tariffs. That's the only comment, Chair, that I had. Thank you.
Thank you very much, Sibanda. I think, Tim, it's clear what you need to do with regard to the provision of an introduction, or just which is going to set the scene in terms of why you're doing this, because this still needs to be of assistance to consumers. I think that's what Mr. Sibanda in essence is saying. And I think that the issue that was also raised regarding the mandate will also come in as part of that context. And a differentiation between what the law allows or provides for vis-a-vis what we do in terms of for example, the time that is that in terms of the law is allowed, within which we need to have completed the assessment and taken the decision, vis-a-vis the time that we would take, which would be could be well within that if information is provided promptly and everything is done expeditiously. So I think that differentiation is of essence. But over to you in terms of responding, Madam Twa and Madam Yokwan and the team.
Sorry, Chair, I just struggled a bit to switch on. Chair, I think from my side, I thought we'll just acknowledge the guidance for improving. And also, if you have indicated, then we'll relook at this before it goes to ER. We're targeting the energy regulator of January. So I guess that gives us sufficient time to just relook at the document and consider what the members have highlighted. I'm not sure if the HOD wants to add anything.
If you can just hold on there, Madam Massetti.
Chairperson, I was going to wait, but also I thought maybe the response that is provided by Ms. Mtwa, I don't think it will be sufficient if one looks at all of the questions that are asked, which are all technical, and really they need to be rephrased, honestly, in the way that they are put. Because remember, sometimes these frequently asked questions, the fact that it is frequently asked questions, we are supposed to bring in what Mr. Sibanda has indicated, that voice the issues that were raised with us, so that this document responds to such frequently asked questions. And we put the context. The way that I'm looking at the questions, Chair, they are too technical, but also even with that, they are not, like if you look at the question and look at the response, you know, I don't know the way that they are framed. There's an issue there, Chairperson, that really needs the team to work on it. I'm not sure if really there's a risk of the timeline here for the team to rework on this document, even if they bring it to the PPS of January, and so that it can be taken to the ER of January still. Thank you, Chair.
I note that I don't know if you can just come in there and respond, because the thing is that I think the provision of the context is going to be important, and also to outline where the general members of the public may pose their questions further for further clarification, because we've also noted that this would normally be used by those who are about to apply, because it's mainly the licenses that need that technical clarification. Hence the issue of the balance, but still leaning more towards assisting licensees who are now intending to apply for a tariff for pipelines. I think that yes, it must assist the public, but it tends to tilt more towards the licenses. But let me hear from your side, Madam Twa and Madam Azani.
Chair, if I may.
Please go ahead, Ms. Bobo.
Okay, thank you so much. Chairperson, yes, we've noted members' comments and concerns, but then I think one last thing I wanted to clarify is that these frequently asked questions are based on the methodology. This is why especially some of the questions may seem a lot more technical, because they relate to sections of the methodology. So we're trying to provide clarity on what's required, on the requirements of the methodology. So, but then we will try and make sure that the questions are straightforward and the responses are completely related to the question asked. But then there may be limitations in terms of being too simple, because they relate to the tariff methodologies. We will try. And then in terms of the time frames, we will do what members are recommending, that we bring this back to PPS of January, and then have it considered by ER if approved or if recommended. Thank you.
Okay, so we members, the suggestion is that the document be enhanced accordingly as guided by the members, but taking due regard of the fact that this in its very nature is going to be a technical document that is aimed at those who seek to apply for a tariff, but it should be crafted in such a way that it is understood by the general members of the public, who at the end of the day are the ones that foot the bill for these storage facilities by way of buying the fuels at the end of the day. So with that, members, if you support the resolution of sending the document back for enhancement, for it to then serve in the PPS of January 2025. By show of hands, members, I see Madam Maseti, Mr. Sibanda, and Advocate Chole. Okay, it's also support that. This then concludes item 5. We'll then move to item 6 on the agenda, which is the Noah Ambrose Park Oil Terminal P2I Ltd's application for the second amendment of the conditions of its licenses issued for the construction of a storage facility and pipelines in Ambrose Park, KwaZulu-Natal Province, which is recommended to the ER by PPS. Is for recommendation. Over to you, Madam Toy, the team.
Thank you, Chair. As indicated, it is
Please take the matter as read and just a few minutes to introduce. Thank you.
Okay, thanks. With that background, may I request that Mr. Lukele then consider the matter as being read and just highlights the reason of the amendment and then talk to the alternative consideration of dealing with such amendments. Thank you.
Thank you, Chairperson, and good morning to everyone. And Chairperson, before I highlight the key issues with this submission, I would like to make a correction on paragraph 2.1.3. It should read the same as the corresponding paragraph under the recommendations on page 10 by referring to 2 addendum, Chair, instead of just 1. Apologies for that, Chair. Taking the submission as read, in this application under consideration, Chair, NAPORT is requesting an extension of the construction commencement date of its project in Ambrose Park by 24 months. NAPORT is requesting to commence the commencement date of construction to be moved from October 2024 to October 2026. The motivation provided by NAPORT Chair for its request is that it was unable to commence with construction due to the dispute with its landlord regarding the lease agreement for the site on which the facility is planned to be constructed. To this end, Chair, NAPORT submitted the evidence of measures it has taken and those that still plan to take to resolve the issue. These measures include, among others, even going to public protector, but then there was a resolution by the public protector as indicated in the submission. Chairperson, the recommendations for the energy regulator to grant the extension requested, and when looking at the effect of the amendment on entry by new competitors, it submitted that the energy regulator approval of NAPORT amendment requested is unlikely to facilitate the creation and or strengthening of barriers to entry in the market segment for the provision of storage facility and pipelines services in Durban and more broadly in the KwaZulu-Natal province. And Chair, as guided, going to looking at the alternative considered, the first one, Chair, was maybe to say, why can't then NERSA consider the revocation or suspension of the license pending the resolution of this dispute? And starting with the revocation, Chair, the view is that when one reads through the provision of the Act that provide for that, which is Section 26, subsection 1 of the Act, that section, Chair, indicates that the revocation under the circumstances maybe will be followed by non-compliance. But how the enforcement of non-compliance is crafted in the Act, first, NERSA will have to give the licensee reasonable time to remedy the non-compliance as provided for Section 25 subsection 1. So for that reason, Chair, that alternative was not supported. The other one for suspension, Chair, on this one, the view is that if the license is suspended, it will be difficult, let's say, for NERSA to monitor the construction, because the only compliance requirement really in terms of this project is for a licensee to submit progress report over and above commencing by a specific date the construction, Chair. So even that was not supported. The last one, Chair, was maybe to approve a different extension and maybe linked this one to the resolution of the dispute. And Chairperson, in terms of this one, Chair, why maybe it was not supported in this case is that stipulation of the construction timelines is one of the means through which NERSA ensure orderly development and also ensure security of supply by ensuring that infrastructure becomes available, and the date on which that should become available is set. And any changes to the stipulated timelines, it's properly considered, and interested stakeholders are given an opportunity to comment on the revised changes. And we submit that, Chair, this is one of the means through this amendment application where NESA really monitor these construction projects. And Chair, I think with that, I will move to the recommendation on page 10 of the submission. It's recommended that the PPS considers and recommends to the energy regulator to approve the following one: the second amendment of the conditions of the 2 licenses issued to NAPORT for the construction of a storage facility and pipelines in Ambrose Park by extending the construction commencement period of these facilities by 24 months, which is from October 2024 to October 2026. Number 2, the decision and reason for decision document attached to the submission as Annexure A. And lastly, Chair, the addendums to the license conditions attached as Annexure 1, Annexure 2, and Annexure 2 to the decision and reasons for decision document. Thank you, Chair.
Thank you, Mr. Lukele. Any questions, comments, or guidance from your side, members, by show of hands? Madam Massetti, and then Advocate Stolle, followed by Mr. Sibanda. In that order, please.
Thank you, Chairperson. Chairperson, I've got 2 issues that I would like the team to address us on, and also to take those issues into account in adjusting their assessment. The first issue is on the very same aspect of entry barriers that the team has looked at, but in the way that the team looked at the entry barriers, they're simply looking at the strategic barriers to entry, to say that, well, the dispute is not caused by the licensee here, and therefore they are not acting in a manner that seeks to prevent entry into the market. So they are looking at the strategic entry barriers in terms of the conduct of the licensee. However, the very entry barriers, the way that we should be looking at as well is it is a supply side response. So you don't just base it on the conduct or strategic entry barriers. So you also have to look at the fact that they have chosen the licensed activity in the area that they are going to operate in. Now, what about other people that would have targeted that very same area? And now we're extending the period from 2024 for almost 2 years. And that would that not foreclose the market for those that could come in and be able to provide the licensed activity or regulated activity? So that is the issue here, the issue of foreclosure, not out of the making of the licensee through the conduct or action of the licensee, something that is regarded as strategic entry barriers, but the fact that there could be a foreclosure of the market if that localized market is so strategic and important for purposes of supplying people from that end. So that aspect has not been looked at, especially because 2 years is always used as a minimum when you look at the entry barriers. Now, if the extension is going to be almost 2 years, that has not been looked at to say whether there could be potential foreclosure of the market, and that analysis did not find its way in the document. So I would like to flag that, Chair. And then the second thing that has not been touched on in the analysis is the impact that the delay would have, especially if the infrastructure that was going to be laid was going to be anchored by certain customers, and looking at the demand for that infrastructure in terms of facilitating the products from that area. So we're not looking at whether we will still have the demand if this infrastructure is not going to be constructed at the time that it was meant to be constructed. We're not looking at that, what impact it will have into the market, and whether the demand that supported or justified that investment, whether that demand will not be impacted if there's going to be a delay of 2 years. And the third point, Chairperson, we need to look into this because if this licensee was issued already early in 2021, now we're sitting at the end of 2024, and there is no movement in terms of the construction of the facilities. That is something that even previously, when we had such incidents or situations, it becomes a problem with regards to the market dynamics, because they might change. And therefore, we find it very difficult, because now all we do is simply to just look at what is before us. Oh, it's an amendment. Let's look into the amendment. But we don't look at whether now we are going to burden the market with infrastructure that may not necessarily be required, because the demand has now changed, and people for the period of 2 years or so may have changed their minds. So market dynamics and the demand side has not been analyzed, and so that we are certain that the infrastructure will still be relevant and it will still be prudent to continue with that infrastructure, because now we are informed by what is likely to happen, and that prudence consideration is not given some thinking in the analysis. Those are the 3 points, Chairperson. I think that it must also be the approach when we look into other amendments going forward, Chairperson. Thank you.
Thank you very much, Madam Maseta. I thought we'll just proceed to Advocate Stolle and then Mr. Sibanda in that order, please.
Oh, okay, Chairperson, thank you. Chair, mine is just 2 points of clarity. The first is whether this license, is it a combined license or do we have 2 licenses issued? Because I think under the subject we're using combined. And in the body, we continue to state that there were 2 licenses that were issued. So I just wanted us to get clarity so that we can ensure consistency in the document. The second point that I have, Chair, is with regard to the authorization, environmental authorization on page 19. It's not stated when it was obtained, but the indication is that it expires in 2028. And I just want to get clarity as to whether is there alignment between this authorization and the term of the license. If not, how are we going to manage the process such that the licensee is not overburdened with really getting into new processes again that they have already done? Because if it expires in 2028 and this environmental authorization, they would have to apply for another one, and therefore then would have to go through our compliance processes as NESA. And noting again the fact that the extension, or rather the second amendment sought, it's going to end in October 2026. So it will be 2 years before the environmental authorization expires. Chair, if that can be clarified for me, I'll appreciate it. Thank you.
Chair, mine is with respect to the alternatives that were considered, in particular the suspension of the license. I think the first issue that I have there is the fact that it comes across as if we're saying because NESA has not suspended a license before, so there's no precedent to rely on. So it comes across as if we're using this as a reason. Maybe if we can reframe it, because I don't think we can use that as a reason, but that's probably is not what we meant, but that's how it comes across, as if because there's no precedent, so we can't do it. Maybe if we can just reframe that to mean exactly what we want to say. But what I also couldn't understand is the last sentence in that paragraph 5.10, which says the difficulty is that the period within which construction must commence should be stipulated in the conditions, and therefore there's no alternative than to process the amendment requested. I just don't get the point that we're trying to bring with that particular statement. Maybe if I can be clarified, because it would appear to me that maybe this could be a possible alternative to use, especially if in future we were to be confronted with an application in the same area, then we could use this as a leeway. I think as Ms. Massetti has indicated, this creates a barrier, whether it's of the licenses making or not, but there is a barrier that's being created. So for me, I think a suspension would have been a better option or alternative. But maybe if I can be clarified exactly what we mean by that particular statement. Yeah, thank you, Chair.
Thank you very much, members. Thank you, Mrs. Banda and Advocate Tole. I will then proceed to the team for responses. Over to you, team.
Thank you, Chair. Also,
You may continue, and then Mr. Sokabase will follow you.
oh, thank you. I will start with the question of Ms. Thank you to the members for
just hold a second. I think Mrs. Banda's hand is still up for something else. Mrs. Banda?
No, Chair, it's a lingering hand, sorry.
All right, no, thank you. You may proceed, Mr. Lukele, and then Mr. Sokabase and other members of the team, if so needed.
Thank you, Chairperson, and thank you to the members for the questions. The ones for Ms. Massetti, I will leave it to Mr. Sokabase to assist. Moving to Mrs. Tole's question, questions in terms of the number, the license issued. It's 2 licenses, ma'am. And apologies, we'll try to make sure that in the submission we are consistent. There were 2 licenses issued. And in terms of the environmental authorization, the date on which that was issued, one will just need to confirm from the records. But I think one can just reflect to say that the NESA license in terms of the validity period, it's up until April 2046. But in terms of these extensions that is being requested to commence construction, it's October 2026. So one can say it's still within the 2028 expiry date of the environmental authorization. But then maybe the chair will just need to add more details in terms of that environmental authorization. What does it entail? In terms of maybe, yeah, we'll improve on that one. Moving to the question from Mr. Sibanda regarding the alternative, specifically the suspension. And here I will also just maybe request our LAS colleagues, if they may, to weigh in. We note that in terms of that paragraph 5.10, maybe one will need to rephrase. Regarding the last sentence there, Chair, what we tried to mean it is that in terms of the construction projects, unfortunately, the date on which maybe infrastructure should become, I think that's where we're coming from, should be set precisely also to address the comments that were raised by Ms. Massetti. I think that's how far maybe that part I will take it. Thank you, Chair. And
Mrs. Sukabas?
Thank you, Chair. Good morning, members, and good morning to the members of the public. I will try to deal with the two questions that Ms. Massetti had as concerns. One on the entry barriers, which are likely to create market foreclosure. Let me maybe start by rephrasing the type of question that we sought to answer in this assessment. So I do understand that the licensee, who's an applicant here, is a license holder, right? So they are basically applying to extend the period of construction. They have previously been granted the license to construct. So the pertinent question then, when one is faced with an application to amend the construction timeline, particularly an extension, the pertinent question is, to what extent is the extension likely to be a strategic delay by the applicant? Now, that is an important question to ask because from a competition assessment, in the previous or initial application to apply for the construction, one would have assessed the need and the entry, in other words, the potential entry by the applicant. But at this stage, where we had already granted the applicant the license, we are more concerned about, is there a license or a potential entrant that would not have faced the similar external circumstances that the applicant in this case is facing. Now, that addresses the foreclosure question simply for one reason. You are trying to look at the extent to which the current applicant is, in a way, trying to create a barrier to entry by extending the timeline. But one has to pay regard to the circumstances surrounding that. Are the circumstances justifying the extension external in nature, in that the applicant did not or is unlikely to be reflecting having made an effort to purport that delay? That's the question that we need to answer. And I think the best way to answer the market foreclosure question is that it's evident, or it's likely to be evident, if that question is answered to be true, to say, okay, there is a potential delay strategy that the applicant is implementing here, hence there is market foreclosure. But if there is no sort of evidence indicating that, it should simply mean that any holder of the license who is extending would have likely faced the similar situation. Let's say, for instance, it was not NAPOT. The same question is to say, to what extent are the circumstances that NAPOT is facing, which necessitated its delay, would be relevant to another firm which would have applied? In other words, are these circumstances immune only to NAPOT? The answer is no. There is a potential likelihood that a similar applicant would have actually faced the similar circumstances. So in other words, in that circumstance, market foreclosure is not much of an important issue to look at, given that the circumstances.
Mr. Sokabas, sorry, let me just interject so that you can have more direction. Let's separate intent from effect. Because the intention could not be one of foreclosing, but the net effect or the impact of what
Yes.
the situation now gives rise to is one of foreclosing.
Yes.
So let's separate that.
Yes.
It's important to do that because
Yes.
these delays, yes, they are coming from the landlord side, but they are not necessarily what we should be just simply taking as is. So if you move from that
Yes.
stance, and please try to be brief and straight to the point in responding. I don't want to pressurize you, but if you may just go on and respond, but do it expeditiously. Thank you.
No, thank you, Mr. Mkizo, for that guidance. I think the straightforward answer to your question is that, firstly, there's unlikely to be intent. But the second question is important. The very circumstances create a barrier to entry. And I would argue that the applicant in this instance is basically foreclosed from entering the market. The very same applicant, not necessarily other firms which would have an interest, but the starting point would be, say, Naport is actually as a result of what you already know. I don't want to actually touch on the confidential matters surrounding the barrier to entry that is created by, I don't want to mention the name, but you know. So that's the point of departure, that Naport is being denied entry. It's unlikely to be the very same applicant that is being denied entry. And that creates market foreclosure from Naport's perspective. Naport is foreclosed as the rest of other market players which would have had an interest. But separation of the two is important. The intent would actually mean that in any event, even if we were to take out Naport out of the equation and put in another applicant, they would actually face the very same sort of foreclosure that Naport is facing. So coming to the question of demand. The question of demand is an important one. But I think to the extent that it may be important, we may want to look at it with caution, because we may determine demand is forecasted to increase at the time when the initial license is granted, right? And then we grant the license, and then the let's say for argument's sake, I'll try to be brief. There are different phases to the project, and then phase one is passed, and then there's an amendment which relates to an extension of timeline for phase two, and then we find that demand at that time doesn't speak to what it was initially granted for. So are we then, what do we do with that? I think that's the very question to say. If we find that there is less demand at that time, remember, demand is forecasted. So are we, I guess the point I want to make is that there has to be some policy certainty from an applicant's point of view. Investment needs to be centered around policy certainty. So when you grant the applicant the license, we simply mean we can move. Then later on, if we look at demand and forecast it not to reflect what the applicant requested for, what do we say? I think that's what I would probably need guidance on, because I would argue that we are unlikely to move from not granting the license, or amending the license on those grounds. Let me pause there. Thank you.
Thank you, Mr. Sokapas. I wanted to come in, but before, let me get Madam Maseti and then Madam Tua, and then I will have something to say after them. Over to you, Madam Maseti.
Thank you, Chairperson. Chairperson, my comment will be to guide. And I would like to thank Mr. Sokapase. This is the kind of questioning and by the team, by any person who deals with matters, to come in and really, show to the members, how the person applied his or her mind. And as you know, Mr. Sokapasa, when we are faced with this kind of inquiry,
if you may please unmute yourself. I think you mistakenly muted yourself.
Sorry. Thank you. Sorry. I was saying that, Mr. Sokapase, as you know, when you are facing this kind or this nature of inquiry, we never base our analysis on assumptions. let me give an example. When you talk about the demand, you ought to have reflected on the demand. You ought to even ask the licensee that, and this is the pertinent question, how this delay is likely to affect the response to the demand that was there in the marketplace. Because now you're going to take a period of 2 years, and a lot can happen in the period of 2 years. You know very well the international standard, even on entry barriers, the minimum being 2 years, what is likely to happen. So all of the questions, whether you go to the OECD, all of the things that are guided in these kind of things, you have to look at the pertinent questions of entry barriers, and the period that one would look at as a minimum is 2 years, because a lot can happen within 2 years. So that is the point of departure. And that would have been justified because of economic arguments that are advanced, and it's a well-established area. So now for the demand, you have not reflected on that, and let alone the policy, but just an assessment. It's a question that a team leader must ask to the applicant, put it to the applicant, then get the response of the applicant, then do an assessment of that response, coupled with the independent information that NERSA would get from the market, in the way that NERSA looks at the market, to juxtapose the answer from the applicant and what NERSA's view on the market in terms of the demand. Otherwise, we'll be left with situations where there is infrastructure that will now be constructed 2 years late, after the time that was approved, which is 2024. And then what then? What if people are no longer interested? Or what if then people who wanted this are affected because they cannot have access to the product and the utilization of the infrastructure? So that did not come through in the assessment, and that is critical. So let's put it there, and it must be a question that is asked from the applicant. Assess that response, but as you assess the response, also give due regard to how you see the market as NERSA in line with the response. That's how it works. And with regards to the issue of the entry barriers, the foreclosure aspect must come through. And remember here, Mr. Mkhize guided properly. It's not about us being concerned about the strategic barriers to say NAPOT is the one who's causing this. No, the fact of the matter and the reality is that there will be foreclosure, or there is an entry barrier. Who caused the entry barrier? We are not saying it is NAPOT. But what we need to do as an economic regulator is to now address the entry barrier that is created, and which is going to be there for 2 years. And if you look at the strategic positioning of this infrastructure when it was chosen, the area of Island View, which is adjacent to this, is an area where there's a lot there. And it's sort of a contested market, so to speak, because a lot of people do want to come in. It may not be a perfect contested market because of the entry barriers, the sunk cost and so forth, but in terms of people wanting to operate in that market. And that's where the foreclosure must be looked at. Thank you, Chair.
Thank you so much, Madam Maseti. Madam Twa.
Thanks, Chair, and thanks for the guidance from the members. We'll have to enhance our the market part, considering that this is an amended, and there was the market analysis done during construction. I think my point before Mr. City came in was to talk on the demand, just to add on the fact that when we initially received the application, the 2 refineries which are now closed were in operation, and that has changed the dynamic and increased the need of storage facilities in the area, because we no longer have the production that we were having from the 2 refineries that have since closed. But I do take guidance that we allow the the licensee to provide their assessment, and then we analyze the information that we receive. But I think it was just to add on the increase in demand for storage facilities for imported final product following the closure of the two refineries. I see Ms. Mahamat wants to come in.
Okay, I think maybe before Mr. Mahamat comes in, for me, the way to go is that this submission, by way of what I'm getting out of these engagements, is that it needs to be reworked. I don't like sitting in meetings where firm decisions are not taken, but it's decisions to say go rework and all of that. No member can enjoy that. But if that's what is required, it's what is required. And I think having also raised some of the issues prior to this submission coming here, but letting it go from a point of view of ensuring that members are well, advised of what the challenges are. One has got it to be this here and now, but I think is that we will have to send it back for reworking. But what of importance is to provide sufficient guidance, because here we're not dealing with an easy matter. We don't want situations where those who are imbued with powers to take certain decisions, delay those decisions, and actually do a lot of harm to our licensees. This matter we have followed up, even myself personally, as in the position of FTRM, primary responsible for petroleum pipelines, even trying to get hold of the people at SIU dealing with the investigations around the issue of the license, the lease agreements and all of that, trying to get this matter resolved very quickly. It has been very difficult. This is not the only licensee. There's another licensee, Lanele, facing almost the same challenge. And the Ambrose Park tenants were hailed as a breakthrough in terms of transforming the industry and making sure that we then have meaningful transformation and there's going to be enough capacity provided to ensure security of supply and to some extent deal with also the issue of congestion at the harbor. But all of that, this whole delay is actually making things very difficult. We've even, in briefing the minister on some of the things, we have raised this matter with the Minister of Transport, who then said, delegated the matter to the DDG, amongst other issues to deal with, to look at really to get something firm and concrete as to what is happening from Transnet side. We do have licenses that they got their licenses, but then there are delays on the other side. We're not saying that Transnet must say yea or nay, must say yeah in terms of this. But for us, what is important, they must just be very categorical and say, this is what is happening, and then we can move on. But the issue of saying, once you've got a licensee and you know that there can be, over the period of time, over the passage of time, you find that the markets, their market changes, the situation changes there, and therefore the license as applied for may not be still valid. Yes, the licensee may not, for simply commercial reason, proceed to construct as originally envisaged anyway, but still we need to do our part. We are working on a first come, first serve basis here, which then also raises a question whether to still include that licensee in the baseline when one considers the balance between demand and supply with regard to the infrastructure that is on the ground or is said coming to be installed. So these are the things that I think this submission should actually be talking to. The principle of saying, let's also not foreclose the very same applicant, unjustifiably so. So we need to deal with that. And I don't think that we need to say we need to have a precedent to this. Let this be the precedent if need be. But these are the tough questions that need to be asked. There can be an extension that, having looked at the market conditions, could come at a lower capacity than the original one, for example. So it's not an easy issue to deal with, noting the issues I mentioned earlier on regarding transformation and how these licenses were hailed as assisting so much in that space. I'll leave it at that without saying much, Mr. Sibanda, and then you can comment. Then I go to Madam Nyebadi, and then back to Sokabas, and then we can close on this. Over to you, Mr. Sibanda.
Thank you, Chair. I think you've covered me, Chairperson. I think there's probably value in also looking at the whole legal question, because I don't think I was particularly answered around the suspension issue. So I would love that to be explored further, and given the pros and cons and all of that. But I'm happy with your summary, Chair. Thanks.
Good morning, colleagues. Chair, you actually covered me on the aspect I wanted to raise on transformation in the industry and how we should be promoting that. But I also just wanted to propose that, given the extent of the discussions and the guidance that we were given, and how our assessment should now reflect the demand and the aspect of foreclosure, would it be possible for the members to consider approving the amendment as proposed, but then we enhance the reasons for decision and bring it back to the members at a later stage? And why I propose this is because, I mean, I'm not trying to preempt what our assessment will say, but we do know that there still is demand for such infrastructure. And our view is still that we should approve this amendment as applied for. On the aspect of suspension that we touched on, and Mr. Sibanda's questions on that, and reflecting on that, in terms of our license conditions, the framework within which we should set our license conditions, Section 20, subsection 1T, actually specifies that the time period within which infrastructure must become operational or should be fixed. And that's why we are limited in terms of going ahead with the suspension. It's just that aspect that it must be fixed. It's not a may, it should be fixed. So that's why we did not go ahead with the suspension scenario. And the revocation aspect as well, there's only 4 scenarios within which you can revoke a license, none of which apply to this particular license. So just that, Mr. Mkhize. Thank you.
Mr. Sokabasa, thank you. Mr. Sokabasa.
Thank you, Mr. Mkhize. Well, mine is just to ask for guidance going forward, because I understand that the analysis for these applications have got, in a way, ripple effects on future analysis. As you correctly said, that even if there is no precedent about previous applications, it may well be the new precedent-setting amendment. So the way I thought about this, and this is really to get guidance from the members, if this is the correct way to look at this. Now, here we have a licensee, right? And the licensee is an applicant for an amendment. For me, that was the point of departure, right? The point of departure would be to look at things from the applicant's point of view. Are they the ones creating this entry barrier? Is it a strategic effort from their side? If the answer is no, we proceed. But the question of whether or not the external factors which the applicant in this case is facing are creating a barrier to entry or not, for me, they are not in any way, in my opinion, they are not in any way related to the applicant per se, because if we take the applicant out of the equation, right, and take Naport out of it and put in, let's say, Zukile One as a firm that would have actually been in the same position, I would have faced the very same circumstances. So the question then is the application, in my opinion, the application which the applicant is submitting, should we approve it or not? And I'm of the opinion that we should not approve it if the applicant is purporting a strategy to inherently create a barrier to entry on its own, because an investigation of a barrier to entry that is external in nature would require us to engage with that party. In this case, I think probably Transnet, right? Which the applicant, in our view, is not responsible for. Now, the second question that I need clarity on to check if my understanding is correct and going forward, I understand the importance of demand, right? Let us say now, arguably so, a scenario like Naport, let's say we find that the forecasted demand, remember it would be forecasted, the forecasted demand does not favor the construction of the facility. What do we then do? What do we decide on? Are we saying there is therefore no need for this facility and we should revoke the license? I guess I want to understand the end result of the assessment as to what do we exactly want to achieve by looking at that and have a clear guidance on how then we treat the demand analysis going forward for existing licensees. If I can just get that guidance, I'd be very happy, so that there can be a clear end result that we're aiming to achieve by doing the assessment. Thank you.
Thank you. I think I did provide guidance on this one. I don't want to actually us to go round and round in circles. I would say that I would rather have a situation where we workshop this in view of the implications affecting other amendments. You recall, some of you will recall that there were instances where there were delays of this nature. We engage the licensee, and at the end of the day, the licensee, when there were engagements, the licensee involved withdrew or revoked, went for revocation, applied for revocation. It's not the intention that matters. It is the effect at the end of the day. And two, it is the responsibility of the licensee to get the requisite permits and authorizations that relate to the license they've applied for. In previous instances, you'd have a situation where the change is such that there are no material changes with regard to the I would say the demand and supply, where you also have sometimes take or pay contracts that remain in force even if there is an amendment. So it becomes a separate issue. The problem that we're having here is also that we've got first come, first serve. So now when you've got an application or a license that has been applied for and granted and issued to the licensee, that then is not getting to the stage of being implemented. Do you then, when you're looking at the market assessment, do you include that license as being in place or not, and thereby declare another applicant as not prudent in the sense that there is no need for it because you have taken this one to be going ahead? So these are some of the difficult things. And I must say, yeah, this matter also touches on both policy and I would say state institutional cohesiveness, because it is the state-owned entity that is causing this delay, with the state apparatuses that are involved in this, that could help in terms of advancing a strategic objective of the very same state. So it's all in one, and we're now in the middle of that. We must take those difficult conditions, those difficult decisions in terms of what our license entails. And really, it's a very sad situation if one looks at especially the transformation of the industry, how this was envisaged, and that here we're not dealing with maybe a private player, we're dealing with state-owned entities and state institutions. So whilst we're following on this matter, I've tried as FTRM primary responsible for petroleum pipelines regulation, followed this matter even personally, talking to the people so that they can be assistance, but there seem to be no movement, and therefore we need to answer those questions. The questions that you have raised, for example, Mr. Sokapas, are the questions that you should be responding to and providing us assistance. Because now you have studied this thing, you have looked at it, you have looked at how the market conditions have changed and what the implications are. I will leave it at that without any waste of time, members. I'm of the view that let's take this back, and if necessary, let us please workshop this, not necessarily because of this application of itself alone, but because of the implications to others going forward, because there are certain things that can change in law, but I don't think that we can have a change in law within a year or 2 years as such, based on the track record in terms of the amendment of legislation in our space. We have sent requests for amendments, we have provided all, but things don't move as fast as one would love to see them moving. So let's take things as they are and move on. Members, if you support that, not necessarily throwing away what Madam Munyebat is saying, but I think that we must write our documents such that they can speak on our behalf in our absence. Members, if you support that, members to the management to work on the guidance provided and then resubmit. Thank you, Mr. Sbanda. Thank you, Madam Maseti. Advocate Story. Advocate Story, are you still there? I don't see your hand. Please unmute. Oh, it's raising a hand in support of returning the submission and to enhance it, and then it will come back to serve here. Let's leave it at that. This then concludes the substantive matters of our meeting. Let's then proceed to the close section of the meeting to deal with these administrative matters. At this juncture, I would just also like to thank all the members of the public that have been following us through the various live streaming channels. Thank members for their comments, questions, as well as guidance that they have provided on the items in this meeting, and management for being receptive of same. Without much ado, let me declare this meeting